Hello. When the Anti Terrorism Act was signed into law earlier this year, there were a lot of groups who protested the law because they said that it was anti-human rights. And also they were saying that the law is unconstitutional. So today we will be examining Republic Act 11479 and study if indeed this law, the Anti Terrorism Act, goes beyond what is allowed by our Constitution. We will not be studying the entire law because it is quite long, but what I will do here is to pick out pertinent provisions and let you decide for yourselves if the Congress who made the law did violate the Constitution, or if, according to you, after you have heard both sides, is the law constitutional and should be implemented by our republic. Since we are studying a law, we will also tackle the basic elements of a law, and then we will examine the law itself, its pertinent provisions, and see if there is any violation against the Constitution. So we will evaluate the law against the Bill of Rights, which is in Article 3 of our Constitution, and also evaluate it according to the principles of separation of powers, also found in our Constitution. So we start off by looking at the enacting body and the session in which the law was made. Here we have S number 1083, which stands for Senate Bill number 1083, and then we have H number 6875, which stands for House Bill number 6875. A bill is an initial form of the law that is proposed by a sponsor either in the Senate or in the House. So that form is the initial form of the proposed law. And finally, when the bill goes through the lawmaking process, then we have the final version, which becomes the law. Then we have Republic of the Philippines, Congress of the Philippines. Congress is the law-making body of the government. It is the legislative branch of the government. That's why all laws come from them, and they are located in Metro Manila. This law was enacted in the 18th Congress. The 18th Congress started from July 22, 2019 and will end in 2022. Now it says first regular session. The first regular session is the first year of the 18th Congress. That's why it says the first regular session began and held in Metro Manila on Monday, the 22nd day of July, 2019. Next, we have the title. Here we have Republic Act 11479. So all laws, they have numbers, and they are numbered according to when they are enacted. And all laws that are enacted in the current Constitution are called Republic Acts. So you will find that previous to that, it might be another act number without the Republic. That's by under the umbrella of another constitution. But anyway, now all our laws have this same nomenclature, which is Republic Act. Now let's read what is the full title of this law. It says, an act to prevent, prohibit, and penalize terrorism, thereby repealing Republic Act number 9372, otherwise known as the Human Security Act of 2007. So, under the Constitution in Article 6, Section 26(1), it says that every bill passed by the Congress shall embrace only one subject which shall be expressed in the title thereof. So here we see that the title of RA 11479 only has one subject, right? It says it is an act to prevent, prohibit, penalize terrorism. But here it says that it repeals Republic Act number 9379. To repeal a law means simply that you're saying that law is no longer effective. No? So once this Act 11479 comes into effect, then the other act, which is Republic Act number 9379, known as Human Security Act of 2007, is no longer effective. That is what it is meant by to repeal. So, let's go further. Be it enacted by the Senate and House of Representatives of the Philippines in Congress assembled. This merely says that the two houses, the Senate and the House of Representatives, have come together in an assembly and they enacted this law. So Section 1, short title, this act shall henceforth be known as the Anti Terrorism Act of 2020. There is always a short title to acts because if you name the act in the full title, you write so many lines just to finish the title. So here, this act, for short, is called the Anti Terrorism Act. Now, in every law, there is always a declaration of policy. This declaration tells us what is the intention of the law. And this is important because once the law goes to a court, the judges will try to find out what was the reason for Congress to enact the law. So let's see, what was the reason why this law was enacted? So here we have, it is the policy of the state to protect life, liberty, and property from terrorism. So there we see terrorism. Number 2, uphold basic rights and fundamental liberties of the people, which shall be absolute and protected at all times. So here it's saying that at the same time, we will uphold the rights and liberties of the people. And number 3, the act shall not curtail, restrict, or diminish the constitutionality, recognized powers of the executive branch of the government. So here we see some definition or some guidelines for the act. And we will know later why this declaration of policy becomes important, because later we will see that there is some question if this act really protects the life, liberty, and property. Does it really uphold the rights and fundamental liberties of the people? Does it curtail or does it expand the powers of the executive branch of the government? So let's hold on to this and see if there's any violation by this act on the policies that it had declared. After the declaration of policy, I did not put down all the declaration of policy. I just chose what was important. We have the definition of terms. There are a lot of defined terms in the law. I also just picked out what I think we should discuss. Otherwise, it's going to be too long. So in Section 3B, there is a definition for designated persons. And these shall refer to any individual, group or persons, organizations, or associations designated and or identified by the United Nations Security Council or another jurisdiction or supranational jurisdiction as a terrorist, one who finances terrorism or a terrorist organization or group, or any person, organization, association, or group of persons designated under paragraph 3 of section 25 of this act. So here we see that you can be, or a person can be designated as a terrorist even without doing anything if there are organizations or councils or some supranational. Supranational means beyond one nation. It could be ASEAN, the countries coming together, and they designate a group or a person as terrorist. And also, aside from those bodies mentioned here, it could also be designated by paragraph 3 of section 25 of this act. So remember, there is this designation of persons in this law. Next, we define what is a terrorist in section 3L. Terrorist individual shall refer to any natural person who commits any of the acts defined and penalized under section 4, 5, 6, 7, 8, 9, 10, 11, 12 of this act. So of course, we'll have to read those sections to know what would be considered a terrorist. So in section 4 of the act, it reads, terrorism. Subject to section 49 of this act, terrorism is committed by any person within or outside the Philippines, regardless of the stage of execution, engages in acts intended to cause death or serious bodily injury to any person, or endangers a person's life. Now, let me read to you from the revised Penal Code, Article 248 and 249. Now, Article 249 defines what is murder. It says, it is committed by any person who shall kill another, except when the victim is his spouse, descendants, ascendants, which is considered parricide. And in Article 249, homicide is defined as killing if killing is not done with the circumstances listed in Article 248. In short, what I'm trying to tell you is, if I present to you these two definitions, one on the left is considered as terrorism, on the right it's considered as murder or homicide. What is the difference? Because both cause death or are intended to cause that death or serious bodily injury or endanger a person's life. Does it sound confusing to you whether you would accuse a person as a murderer, as a homicide, as person who committed homicide, or as a terrorist if I just give you these two definitions? So there, our definition of terrorism becomes a bit unclear. But we go further. And going on, our section 4B says a terrorist also is someone who engages in acts intended to cause extensive damage or destruction to a government or public facility, public place, or private property. So here, somebody who causes damage, extensive damage, to public facility or private property. And C, it says engages in act intended to cause extensive interference with, damage, or destruction to critical infrastructure. So here, we have an idea that a terrorist is somebody who causes extensive damage to property. So this again is the definition of the Anti Terrorism Act. Again, we will compare this to the revised Penal Code. Article 324 of the revised Penal Code defines what is crimes involving destruction. I have to read it to let you understand. I'll read. Any person who shall cause destruction by means of explosion, discharge of electric current, inundation, sinking or stranding of a vessel, intentional damaging of an engine of said vessel, taking up the rails from a railway track, maliciously changing railway signals for the safety of moving trains, destroying telegraph wires and telegraph posts, or those of any other system, and in general by using any other agency or means of destruction as effective as those above enumerated, shall be punished by reclusion temporal if the commission has endangered the safety of any person. Otherwise, the penalty of prison mayor shall be imposed. What I'm trying to show you here is this article punishes the destruction of property by means of it means that you use explosives to, here it's listed as explosive, electric current, inundation meaning sinking. So these are ways of damaging property, and this is a crime defined in the revised penal code. And if you look at how section B and C, or section 4 B and C defines a terrorist, you would say that it's very close and in fact similar to the crime described here in Article 324. And we go on to D and E of section 4. D is develops, manufactures, possesses, acquires, transports, supplies, or uses weapons, explosives, or of biological, nuclear, radiological, or chemical weapons. And E, release of dangerous substance or causing fire, floods, or explosion. So again, on the left, you have the Anti Terror Act. And on the right, you have the Penal Code. What does the RPC, or the Revised Penal Code, penalize? Here we have Article 254, discharge of firearm. So any firearm, if you discharge it, that is a crime. Article 320 and 321 criminalizes arson. Arson is when you destroy a property by fire. So it's the same as in E, releasing of dangerous substance or causing fire. And another law, Republic Act 10591, titled Comprehensive Firearms and Ammunition Regulation Act, in Section 24, it criminalizes unlawful acquisition or possession of firearm and ammunition. And also in Section 29, use of loose firearm in commission of a crime. In Republic Act 10697, it is an act preventing the proliferation of weapons of mass destruction. So here, although we don't really have something that address biological, nuclear, radiological, or chemical weapon, we do have an act which penalizes the proliferation of weapons of mass destruction in Republic Act 10697. So once again, we see that there are a lot of overlaps in this law. And we will see in the last paragraph how it tries to differentiate the listed crimes in Section 4 of the Anti Terrorism Act and those of the Revised Penal Code. So here, in the bottom part of Section 4, it says, these are considered terrorist acts when the purpose of such act, by its nature and context, is to intimidate the general public or a segment thereof, creating an atmosphere or spread a message of fear to provoke or influence by intimidation the government or any international organization, or seriously destabilize or destroy the fundamental political, economic, or social structures of the country, or create a public emergency, or seriously undermine public safety, shall be guilty of committing terrorism. So here we see that the law lists other circumstances that must be present before the crime is considered as a terrorist act. So what are these? We will examine this paragraph one by one in the next slide. So here we have the elements that must be present. Only one needs to be present for it to be considered as a terrorist act. So the act has to intimidate the public, the general public, or it creates an atmosphere or create a message of fear, or to provoke the government, or to seriously destabilize the fundamental political, economic, social structures of the country, or create a public emergency, or seriously undermine public safety. Now, let me ask you, if there is a murder that happens in your neighborhood, don't you think that it creates a message or an atmosphere of fear? Don't you think that a murder story in your neighborhood will intimidate the general public? So these elements here they don't seem to define really terror acts. They seem to apply to ordinary or general crimes in the same way as they do terror acts. So the problem is, how do you differentiate that an act is considered as an act of terrorism or merely a criminal act that does not warrant it to be termed as a terroristic act? Now, if the definition of terrorism as defined in Section 4 of this Act ended in the previous slide, then we would have strong reason to say that indeed the definition of terrorism is very broad. But what Congress added in this section is this particular paragraph here. And it reads, provided that terrorism as defined in this section shall not include advocacy, protest, dissent, stoppage of work, industrial or mass action, and other similar exercise of civil and political rights, which are not intended to cause death or serious physical harm to a person, to endanger a person's life, or to create a serious risk to public safety. So this paragraph is telling us that so long as the protest that is done does not cause death or serious physical injuries, or endanger another person's life, or create serious risk to public safety, then it's not considered as a terrorist act. So, for instance, the students of Davao City wants to go out there and do a peaceful protest for a particular grievance, then it's still okay to do so if it doesn't involve any of the things listed at the end of the paragraph. So it's still okay to go out to have a strike, for instance. That's industrial mass action, because these are recognized as rights, our rights as citizens, and these are our civil and political rights. So this paragraph here is what the lawmakers are saying, that it's not really a violation of our rights, because we can still go out and do advocacy and protest. It's allowed under this law. So technically, there is no violation of any of our rights. Now, aside from Section 4, which we read in detail earlier, the definition of a terrorist act also included Sections 5 to 12. So I'm just giving you the headings of the sections. So Section 5 is threat to commit terrorism. Section 6 is the planning, training, preparation, and facilitating the commission of terrorism. 7, conspiracy to commit terrorism. And when there are 2 or more persons, it's already considered conspiracy. Proposal to commit terrorism. Inciting to commit terrorism. Now, when you incite something, there's normally a talk or a publication when you try to convince other people to commit terrorism. Section 10, recruitment to and membership in a terrorist organization. Section 11, foreign terrorists. Section 12, providing material support to terrorists. Now, this one is controversial because if you provide food to the terrorists, of course, you have to know that they are terrorists. Then you would also be a terrorist under this law. So it's very broad. The definition of a terrorist act under this law is very broad. That's why there's a lot of people asking the courts to strike this down as unconstitutional. But I want you to think if it really needs to be struck down, because remember, we are fighting terrorism here. No? So let's proceed. Now, our Constitution in Article 3 of the Bill of Rights, Section 4 and 8 reads, "No law shall be passed abridging the freedom of speech, of expression, or of the press, or the right of the people peaceably to assemble and petition the government for redress of grievances." So this is where our right to protest to the government comes from. It comes from our Constitution. And in Section 8, it says the right of the people, including those employed in the public and private sectors, to form unions, associations, or societies for purposes not contrary to law shall not be abridged. So we have rights granted in the Constitution, and these rights are supreme, and no law should abridge those rights. No law should violate the rights that have been granted by the Constitution. That's why when you want to examine a law, normally you would examine the constitutionality of the law. Does the law violate any of the provisions in the Constitution? So here we see that under the Bill of Rights, we have Section 4 and 8 saying that we can go and protest. That's a freedom of speech. We can go and peaceably assemble and petition to the government if there are any grievances. And we have the right to form unions and associations. So does the law, anti-terror law, violate the rights granted to us in the Constitution under the Bill of Rights? Now you might ask, why is the Constitution so powerful? Now, if we read the preamble of the Constitution, 1987 Constitution, it reads, "We, the sovereign Filipino people, imploring the aid of Almighty God in order to build a just and humane society and establish a government that shall embody our ideals and aspirations, promote the common good, conserve and develop our patrimony, and secure to ourselves and our posterity the blessings of independence and democracy under the rule of law and a regime of truth, justice, freedom, love, equality, and peace, do ordain and promulgate this Constitution." Now, this preamble is very important because who is the one who promulgated the Constitution? Is it the Congress? Is it the President? No, it is we, the sovereign Filipino people. See? So it is the people who promulgated this Constitution, this body of law by which the Filipino government has to abide by. That's why any law that is enacted has to abide by the provisions of the Constitution because it is enacted by the sovereign Filipino people. So we now have our first set of questions. The first question is, does the anti-terror law poorly define what constitutes a terrorist act and include crimes which are found in the revised penal code which may easily be construed as a terrorist act under the law? So remember we discussed about murder and homicide and say that it could be a crime under the revised penal code, and at the same time it could be a terrorist act under this law. So the difference here is the penalty. The penalty under the Anti Terrorist Act is much higher than that in the revised penal code. And at the same time, there are crimes that may not really constitute as crimes, especially if you are just giving support, a supply to the terrorists. Example, you are a commercial establishment and you are selling the terror group food, and maybe you're not really sure if they are really terrorists, but you suspect they might be terrorists, and that makes you a terrorist as well under this act. So does the act poorly define what constitutes a terrorist act? And number two, does the anti-terror law as written limit your freedom of expression, which is safeguarded by the Bill of Rights in the Constitution, by sending a message that such protests may be seen as a terrorist act? Now, earlier we read under the Bill of Rights that we have the right to redress the government for any grievances that we have. But the way that the Anti-Terrorist Act is written, don't you think that people will now hesitate to go out in the street and protest? Because whoever they are, when they're out there in the street, the government might just brand them as terrorists. And because of their protests, jail them or punish them as terrorists. So that's the first set of questions that we have against this law. So what do you think? Now, the second set of issue that I would like to address is the length of detention after arrest. Is it a violation of the Constitution? So let's see why there is such an issue. First, we shall read a crime defined by Article 125 of the Revised Penal Code. It is entitled, Delay in the Delivery of Detained Persons to the Proper Judicial Authorities. So this crime is given to people or public officers who detain any person and fail to deliver them to the proper judicial authorities within 12, 18, or 36 hours, depending on the length of time that their criminal act is punishable by. So what this is saying is that when a police officer arrests a person, that police officer has to present the arrested person to the courts at most within 36 hours. Otherwise, that police officer would have committed this crime, delay in the delivery of detained persons. Now, there has been court cases that say that this 36 hours is not that strict, that if there's a holiday, if there is weekends, it is acceptable to extend the 36 hours. But these are within reasons. The law still requires that any person who is detained to be presented to the courts so that the courts will determine whether his detention or arrest is valid or not. Now let's compare this to the Anti Terrorism Act of 2020, Section 29. Now this section is long. You may want to read it for yourselves later, but basically what this is saying is if a person is arrested and that arrest was with the written authority of the Anti-Terrorism Council, that person may be held without being presented to the judicial authority for a period of 14 days. And this 14 days can even be extended for another 10 days if there is valid reasons. So here we see that the period, the limited 3-day period that was enacted in the revised penal code has been extended to basically 24 days. So this is another very contentious section of the Anti-Terrorism Act. Will this lead to abuse by police officers when they arrest people under this law? And going to the 1987 Constitution, again in the Bill of Rights, Article 3, We have Section 15 that says the privilege of the writ of habeas corpus shall not be suspended except in cases of invasion or rebellion when the public safety requires it. What this is saying is you cannot arrest a person without reason. And writ of habeas corpus is the legal action that detainees can use when they are unlawfully imprisoned. So there's only two instances when you can arrest a person without giving them over, turning them over to the judicial authority, and that is during periods of invasion and rebellion. That is in the Constitution. Other than that, you have to turn over arrested persons within a reasonable time. And Section 16 says, all persons shall have the right to a speedy disposition of their cases before all judicial, quasi-judicial, or administrative bodies. So this is a right of the accused. Whenever somebody is accused and arrested, he shall have the right to a speedy disposition. That means you can't have that person wait forever. And he doesn't know if he is to be seen as guilty or not, if the judge will proclaim his guilty or not. So we have to give that person a speedy disposition of his case. He cannot be made to wait forever, and that is a right guaranteed under our Bill of Rights. So the question we have here is the detention for 24 days, which is the 14 plus the 10-day extension, is that 24 days without delivering the accused to the judicial authority a violation of speedy disposition of cases protected by the Constitution? Now, the Constitution doesn't say how many number of days a person must be presented, but it just says that you have to speed up. You can't delay. But we have a law. The revised penal code says that once a person is held for more than 3 days, the arresting officer violates a law. It is criminal. But it doesn't apply to this case. The 3 days doesn't apply to this case because this law says, notwithstanding what is said in the revised penal code, we can detain a person for 24 days. So my question to you is, if somebody is arrested for 24 days, does that violate his right to speedy disposition of his case? What do you think? Is it too long? Or is it just right, since this is, after all, a terrorist act and maybe requires more investigation, more, I don't know, there are more issues involved. So my question to you is, do you think the 24 days is reasonable? So moving on, the third issue we have is this issue of designating people or organization as terrorists. Now, in Section 25, this is a very contentious provision in this Act, Section 25. It reads, designation of terrorist individual, groups or persons, organizations, or associations. So, pursuant to our obligation under the UN Security Council Resolution number 1373, the ATC is the Anti Terrorism Council, shall automatically adopt the UN Security Council consolidated list of designated individuals, group of persons, organizations, or associations designated and or identified as a terrorist, one who finances terrorism, or a terrorist organization or group. Requests for designations by other jurisdiction or supranational jurisdiction may be adopted by the ATC after determination that the proposed designee meets the criteria for designation under UNSCR number 1373. The ATC may designate an individual, group of persons, organizations, or associations, whether domestic or foreign, upon a finding of probable cause that the individual, groups of persons, organization, or association commit or attempt to commit or conspire in the commission of the acts defined and penalized under Section 4, 5, 6, 7, 8, 9, 10, 11, 12 of this Act. The assets of the designated individual, groups of persons, organizations, or association above mentioned shall be subject to the authority of the Anti-Money Laundering Council to freeze pursuant to Section 11 of RA 10168. The designation shall be without prejudice to the proscription of terrorist organization, association, or groups of persons under Section 26 of this Act. So, I want you to concentrate on the third paragraph. It says that the ATC may designate any individual, groups of person, organization, or association if they find probable cause that that individual, groups, or organization is attempting to commit or has committed or is conspiring to commit. Now, the problem is here is that it's very difficult to it's very difficult to designate a group as attempting to commit. And who is the ATC anyway? Do they have this power to designate a group as terrorists? And how would the persons under suspicion have the ability to defend themselves? Can they defend themselves? According to this provision, they don't have the right to defend themselves because the ATC can do it on their own, so long as they find probable cause that that group is a terrorist. That's why Section 25 is a very contentious provision in this law. Now, I pulled this website out of the cnn.ph website, and the news article reads, "Government to publish names of designated terrorists. Appeals for delisting can be filed after." So this is the effect of being designated as a terrorist. Your name will be listed on a website or on a bulletin board without you participating. And then if you have cause to think that you're not really a terrorist, then you can file an appeal to delist after. So it's as if saying that you're already guilty without even participating. What happens to the idea of a person is innocent until proven guilty? What happens to that in this case? Something that has not been respected in this case. So let's see further. Once again, we go to the Constitution because this is where all our rights come from. Again, in Article 3, Bill of Rights, Section 14(1) says, "No person shall be held to answer for a criminal offense without due process of law." Now, when you say due process of law, it means that that person should be able to answer. What are the charges against him? He should know what are the charges against him. So, when the ATC designates a person as terrorist, this one never happens because it's only the ATC acting on their own when they designate a person as a terrorist. And in 2, it says, "In all criminal prosecutions, the accused shall be presumed innocent until the contrary is proved." There it is. It says, "Accused shall be presumed innocent until proven guilty, and shall enjoy the right to be heard by himself and counsel, to be informed of the nature and cause of the accusation against him, to have a speedy, impartial, and public trial, to meet the witnesses face to face, and to have compulsory process to secure the attendance of witnesses and the production of evidence in his behalf. However, after arraignment, trial may proceed, notwithstanding the absence of the accused, provided that he has been duly notified and his failure to appear is unjustifiable." Here it lists what are the rights of the accused. The accused shall have the right to be heard, shall have the right to be informed of the accusation against him, shall have the right to a speedy, impartial, and public trial, shall have the right to meet the witnesses face to face. Compulsory process means they have the right to ask the court to help them to secure a witness or to produce evidence. But these are the rights of the accused guaranteed in the Constitution. And it seems that the Anti Terrorist Act do not give these rights to the accused when they designate a person as a terrorist. So that's another point of contention against this law. One of the effects when a person is designated as a terrorist is a freeze order, which I read here. It says, the freeze order shall be effective for a period not exceeding 20 days. So the freeze order is on the assets of the designated terrorist. So once a person is designated as a terrorist, the ATC can freeze his assets. So that is something that happens when you are designated as a terrorist. Now, yes, a person designated as terrorist is not immediately arrested. He is not, according to this law anyway, there is no immediate arrest, but one of the rights of the ATC is to freeze the asset. Now I want to present to you what is the definition of a crime or criminal penalty. A criminal penalty means any criminal sentence. Criminal sentence means there is jail time, or a penalty or fine or similar liability imposed upon any person for such person's action, omission, or violation. So what I'm trying to say is an act becomes a crime if there is a penalty of imprisonment or when the penalty is a fine. So a fine means you have to pay something. Let's say you damage a property. You have to pay for the property. So that's a fine. So it becomes a criminal offense. Now here, the government doesn't take the designated terrorist asset, but it just freezes it. So the designated terrorist cannot use it. So technically, it's not a fine. It's just freezing the asset of the designated terrorist. So the lawmakers can argue that we're not violating any right of the accused because we're not taking his money. We're just freezing it. We're just making life difficult for him. In fact, this is not a criminal proceeding yet because we are not imposing any penalty. So if it's not a criminal proceeding, the rights of the accused that we read in the earlier slide should not apply. See my flow of argument? So if it doesn't apply, then this law does not violate the Constitution. So what do you think? What do you think? Is freezing the property considered as a penalty against the designated person or not? We'll see further. But going back to section 29, which we saw earlier, here in section 29, I have to read the first few sentences. It says, detention without judicial warrant of arrest. The provision of Article 125 of the Revised Penal Code to the contrary notwithstanding, any law enforcement agent or military personnel who, having been duly authorized in writing by the ATC, has taken custody of a person suspected of committing any of the acts defined under section 4, 5, 6, 7, 8, 9, 10, 11, 12. What I'm saying here is the ATC can issue an authorization to the police or military personnel to arrest a person. So what would stop the ATC from issuing an authorization to arrest a designated terrorist. See what I mean? So even if the law doesn't say that a designated terrorist has to be arrested, but this law in Section 29 says that the ATC can issue a written authorization to arrest a person suspected of being a terrorist. So before we were saying that it's not really a crime because we're not taking the person's property. But here in Section 29, we see that the ATC can order the arrest of the person. So technically, again, it becomes a crime. It comes under the purview of criminal law. And once it comes under the purview of criminal law, the rights of the accused that we read in the two earlier slides will apply. Okay? So it's getting more interesting. Then we have this question, judicial or executive? Now remember earlier we said that the ATC will determine if there is probable cause to designate someone as a terrorist. So the question is the determination of probable cause a judicial or executive function? Now, probable cause is what you have to go through to determine if you have cause to believe that somebody committed the crime or not. That's the simple way of putting it. Now, it depends who. There are two people who can determine probable cause. First is it is an executive function, and the second, it can be a judicial function. Now, what's the difference? Let's read. Executive function. The purpose of determining whether there is a reasonable ground to believe that the accused has committed the offense and should be held for trial. The other one is judicial function. Issuance of warrant of arrest by a judge. So there's two different situations here. The judge will issue a warrant of arrest and is the person who is responsible to determine if there is probable cause when that person is not yet arrested. When the police still has to go and get that person. But once a person is already arrested by the police, it becomes the duty of the executive branch to determine if that accused who is under custody has committed the offense and should be held for trial. This is where the prosecutor comes in. The public prosecutor comes in to see, or before we used to call it the fiscal. Before the fiscal, he will determine if that person who has been brought in by the police, if there is probable cause to file a case against this person based on the evidence that has been given by the police. So we see here two different scenarios. If the person has not been arrested, you need a judge to issue the warrant. If the person has been arrested already, then it is the fiscal, which is under the executive branch, to determine if that person has to be held for trial. So, two very different things. Now, we equate this to the Anti Terrorism Act, the function of the ATC, which one are they doing? Are they doing the first function or the second function? I would say that they are doing the judicial function if, according to Section 29, they can issue a written authorization to the military to arrest somebody. That's equivalent to issuing a warrant of arrest. And that function can only be done by a judge. But those sitting in the ATC, the Anti-Terrorist Council, do they belong to the judicial branch or do they belong to the executive branch? Unfortunately, later we will see that they belong to the executive branch. So If they belong to the executive branch, do they have the power that has been given to the judicial branch? So that's another constitutional issue. Let's discuss this further. Here in section 25, we have here the list of people who comprise the Anti Terrorism Council. The Anti Terrorism Council is hereby created. The members of the ATC are the Executive Secretary, who shall be its chairperson, the National Security Advisor, who shall be its vice chairperson, the Secretary of Foreign Affairs, the Secretary of National Defense, the Secretary of the Interior and Local Government, the Secretary of Finance, the Secretary of Justice, the Secretary of Information and Communications Technology, the Executive Director of Anti-Money Laundering Council Secretariat as its other members. Now, if you look at all these 9 people listed here, these are all positions of the executive branch. None of them belong to the judicial branch. So once again, the ATC is a purely executive council, but they seem to be able to issue authorizations to arrest a designated terrorist. And once again, we go to the Constitution. Now, Section 2, let me read. The right of the people to be secured in their persons, houses, papers, and effects against unreasonable searches and seizures of whatever nature, and for any purpose, shall be inviolable. That means it cannot be breached. And no search warrant or warrant of arrest shall issue except upon probable cause to be determined personally by the judge after examination under oath or affirmation of the complaint and the witnesses he may produce, and particularly describing the place to be searched and the person or things to be seized. So here, the Constitution defines clearly what is the standard of issuing a warrant of arrest. First, it says it has to be only the judge can determine the probable cause to issue a warrant of arrest. And then it says the judge has to examine the complainant and the witnesses. So there has to be somebody who tells the judge, oh, this is why I think that person has to be arrested. And witnesses have to be presented to the judge. So when we look at the power of the ATC, the law never gives this limitation to the ATC. It seems that the ATC, without anyone coming to them, without examining the person who is doing the accusation or the witnesses, the ATC issues an authorization to arrest. So again, I think this is a flagrant violation here if the ATC truly issues the authorization to arrest. Another principle that is violated by the ATC when it issues a warrant of arrest is the separation of powers that is ingrained in our Constitution. The separation of powers actually gives accountability and check and balance in our government, our system of government. In Article 6, which defines the legislative government, it gives legislative power to the Congress of the Philippines. And that Congress, as we mentioned earlier, consists of the Senate and House of Representatives. And the people also have that power by initiative and referendum, but that's another issue. So, what is legislative power? That's the power of making laws that is given to the Congress. Next, in Article 7, Executive Department. The executive power shall be vested in the President of the Philippines. So, in the Executive Department, which the President is on top and all his secretaries below, they have executive power. They can run, they operate the government. That's all under them. In Article 8, we have the judicial department, and these are the courts and the judges. So the judicial power shall be vested in one Supreme Court and in such lower courts as may be established by law. So we see here the three separate branches of government, and their powers cannot mix. Making laws belongs to legislative. The executive, which is to carry out the laws, is given to the executive, and to judge is given to the judicial. Yes, there are times that executive departments are given quasi-judicial function, but that is within their scope of specialization. Example, you have the IPO, that is the Intellectual Property Office. They have some quasi-judicial powers when they deal with cases involving intellectual property laws, because they are experts in that, and the law gives them that kind of quasi-judicial power. So here, the Anti Terrorism Council, they seem to have judicial power, but is this a quasi-judicial power? Quasi means not purely. You have a little bit, quasi, you have a little bit of judicial power. But the Anti-Terrorism Council, they don't have a specialization, or they don't purely just function to catch terrorists. So they're not really specialized in this function. So there's really no reason to give them quasi-judicial power when it comes to terrorism. So going back, giving the Anti-Terrorism Council the ability to issue warrants gives them the function that it should just be vested in the judicial department. So it actually violates the separations of powers that is in our 1987 Constitution. And now we come to the last part of the law, and that is the effectivity. All laws have this section, and it tells us when the law is effective. For this, it says that the law will take effect 15 days after publication in the official gazette or at least 2 newspapers of general circulation. Now, the official gazette is the official publication of the government, and laws used to always be published on that gazette. And now we have an e-copy of the official gazette, which you can Google. And here it says if it's not published there, you can also publish it in 2 newspapers of general circulation. And we see that the leaders of the House of Representatives and Senate signs the law. So here we have Alan Peter Cayetano as the leader of the House of Representatives, and he is called the Speaker as the leader of the House. And then we have Vicente C. Soto, and he is the President of the Senate. And at the bottom, we see that it is approved by our President, and that is what is required of a law. It requires to be approved by the President, or if it gets approved without signature, that's also fine. If there's no signature after 15 days, that's also fine. And so here we have presented to you the Anti-Terrorism Act of 2020. Now, there are several cases or actions filed before the Supreme Court questioning the constitutionality of this law. And many of those cases have presented the issues that we have discussed here. Now, the Supreme Court may take either of 2 actions. It may decide on the cases that are filed before it, or since there is really nobody whose rights have been impaired by this law yet, the Supreme Court might also say, there's no right violated yet. We will wait until a person's right is violated before we discuss the constitutionality of this law. Okay, so it can either do that, or it can say, oh, this issue is of transcendental importance, we will decide on it now. So we don't know which course of action the Supreme Court will take. Now, in my own view, which I don't know if it's going to amount to anything, but in my own view, I think that there are some provisions in this law that is unconstitutional. And the Supreme Court will not strike down the entire law as being unconstitutional. Very often what they will do is they will say, this part is unconstitutional, and we will strike it down for being unconstitutional. But it still leaves the law as a valid law. And of course, it can also say that we will strike the whole law down as unconstitutional. But I don't think the Supreme Court will do so here, because I think the Supreme Court, the justices, still recognizes the need to go against terroristic acts. So I think they will keep the law valid, but they will just strike down provisions that they deem unconstitutional. But we will have to wait what the Supreme Court will decide on this matter. And I guess that will be the second part, if ever, when the Supreme Court comes out with that decision, to see what will happen to this Anti-Terrorist Act of 2020. And with that, I say goodbye.